Welcome to the Office of Tax Appeals. We're ready to begin with the appeal of Brayton. The OTA case number is 210-37435. The oral hearing is being live streamed. Also present is the stenographer, Ms. Alonso, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speaks one at a time and does not speak over each other. Also, speak clearly and loudly. When needed, Ms. Alonso will stop the hearing process and ask for clarification. After the hearing is over, Ms. Alonso will produce the official hearing transcript, which will be available at the Office of Tax Appeals website. My apologies, I'm being corrected. Ms. Rodriguez is our stenographer today. My apologies. After the hearing, Ms. Rodriguez will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. As a reminder, these proceedings are being broadcast live, and anything said today and any information shared today is publicly viewable on the live stream. With that said, are there any questions before we go on the record? No? Okay. Then
Actually,
Ms. Rodriguez, if you're ready, we are ready to go on the record.
Judge Long, I
Yes,
apologize.
go ahead.
I wanted to correct the spelling of my name. My first name ends with a T, not an F.
Okay.
Thank you.
Noted. Thank you very much. Okay. We are opening the record in the appeal of
Judge Long, I'm sorry. One more question before you go on the record. Are we on the record yet?
We were about to go on the record,
Okay.
but we can stay off.
I did have one question regarding the submission of the appellant's exhibits. They submitted, looks to be about 1,038 pages of exhibits a couple of weeks ago. And we have no objections, but they aren't really numbered or designated in the way that was indicated or requested in the orders and minutes. So I guess I'm just wondering how we're handling referring to those. Are we referring to them by page number? If we are referring to them, or if the appellant does, just so we can kind of keep track of how they're being referred to, I guess.
You're right. The exhibits are not numbered in the way that I requested in the minutes and orders document or at the pre-hearing conference. And the pages aren't numbered either. However, they are clearly labeled alphabetically and in a way that is navigable. So rather than create additional workload for the taxpayer's representative, I chose not to say anything. I will be referring to them as appellant's exhibit and then the number if I have to refer to them. And I request that each of you do the same. Sound good?
I guess I'm not really clear about what the reference would be. I have 1,038 pages, and there's no citable, or there's no distinction between the pages that can be easily navigable, I guess.
I think that you might be looking at the wrong thing. I have an exhibit index labeled exhibits A through J, and then each exhibit at the first page of the exhibit has a exhibit letter.
Yes, and it should be
I don't think
around
we have that, Your Honor.
223 pages, is my belief as well.
Okay.
We've got 1,038 pages.
That was
and they don't have those labels on them.
okay. The exhibits should have been provided to you as well. So here's what we're going to do. We're already off the record, so we don't need to stop the record. Mr. Canestrelli, Mr. Tucker, do you have the exhibits available to?
Yes, we could email them or share them in the chat, whichever you prefer.
Well, don't share them in the chat.
Okay.
But emailing them would be helpful at this time.
Okay. We will email them
and
right now.
Thank you. So what I think we should do at the moment is everyone should just mute their microphones and turn their cameras off. And then Mr. Miller and Ms. Calipari. Wait, I wasn't done yet. I didn't say go. What when you receive the documents, please let OTA know, and then we can resume the hearing. Does that sound like a plan?
Yes.
Do you want to say something about your name?
Okay, then now everyone turn off their cameras and mute their microphones. Before we go on the record, are there any further questions? Okay,
Question, Your Honor. It appears that these are similar documents to what was already submitted multiple times, but without having a chance to review all 223 pages carefully, I'd just like to reserve the right to object at a later time. This is our first time looking at it, but I don't anticipate any objections. I just wanted on the record that we haven't had a chance to review these, so we would like to reject objections.
okay, so what I am going to do then is at the end of this hearing, instead of closing the record, I will leave the record open and give you 30 days to file any objections. And then Mr. Canestrelli, Mr. Tucker, you will be given the opportunity to respond to objections. And then I'll make a decision on those arguments as well. Okay?
Thank you.
All right. Mrs. Rodriguez, are you ready to go on the record? Excellent. We are opening the record in the appeal of Brayton. The OTA case number is 210-37435. This matter is being held before the Office of Tax Appeals. Today's date is September 17th, 2024, and the time is approximately 2:30 p.m. This hearing is being convened electronically. Today's hearing is being heard by a panel of 3 administrative law judges. My name is Keith Long, and I will be the lead administrative law judge. Judge Veronica Long and Judge Natasha Ralston are the other members of this tax appeals panel. All 3 judges will meet after the hearing and produce a written decision as equal participants. Although I will conduct the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all of the information needed to decide this appeal. As a reminder, the Office of Tax Appeals is not a tax court. It is an independent appeals body. The panel does not engage in ex parte communications with either party. OTA will issue an opinion based on the party's arguments, the admitted evidence, and the relevant law. As a further reminder, since it's been a few minutes since we started, today's hearing is being live streamed, so anything that you say or display on screen will be seen on the internet, and we do request that you don't use the chat function within Zoom. For the record, will the parties please state their names and who they represent, starting with the representatives for appellant.
Hi, I'm Pietro Canestrelli, and I represent appellate Alan Brayton.
Good afternoon. I'm Justin Tucker, and I represent appellant Alan Brayton.
Good afternoon. I'm Kamalpreet Kara. I represent Respondent Franchise Tax Board.
Good afternoon. My name is Matthew Miller, and I represent Respondent Franchise Tax Board.
Thank you. There is one issue in this appeal, and that is whether appellant has established that he is entitled to deduct his pro rata share of a bad debt deduction. My understanding is that we have 2 witnesses today at the pre-hearing conference and an appellant's pre-hearing conference statement. Appellant indicated that their witnesses would include Alan Brayton and Richard Spies. As a reminder, witness testimony is not required for an oral hearing. However, testimony given under oath may be considered as evidence. Additionally, FTB is given the opportunity to cross-examine any witnesses. Would appellant please confirm that it will present testimony, witness testimony during this hearing?
Yes, confirmed.
Thank you. I will take the witness affirmations now. Mr. Brayton and Mr. Spies, would you please raise your right hands? Mr. Spies, you'll have to unmute for this one. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
I'm sorry, I'm not sure which person answered on that one.
Mr. Brayton answered.
Mr. Brayton and Mr. Spies, I couldn't hear you. Do you swear to tell or affirm to tell the truth, the whole truth, and nothing but the truth? It appears that your microphone is not working. Can't hear you. It may be that your microphone is muted on the computer instead of just on this Zoom program. Now it's muted on the Zoom program as well. Mr. Spies, we're going to take a quick pause in the hearing. We'll take 5 minutes and someone from OTA will reach out to you and help you with your microphone. In the meantime, we're going to go off the record. I am going to return everyone to the waiting room for the hearing, and the ALJs will all mute their microphones and go off camera for now. Okay, and we should return at 3:02. Thank you. Can we hear your voice now?
I hope so.
Yes, good. Okay. Let's go back on the record because I believe we have everyone. Ms. Rodriguez, are you ready again? Okay. We are back on the record. Mr. Spies, let's start from the beginning here. Would you please raise your right hand? And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may lower your hand. All right, moving forward to exhibits at the pre-hearing conference and in appellant's pre-hearing conference statement. Wait, that's the wrong line. The exhibits for this appeal consist of FTB exhibits A through S. At the pre-hearing conference, appellant had no objections to these exhibits. Mr. Canestrelli, Mr. Tucker, would you please confirm that there are no objections at this time?
No objections.
Objections.
FTB exhibits A through S are admitted with no objections. After the pre-hearing conference, appellant timely provided an exhibit index identifying exhibits A through J. FTB received the exhibits in the format that OTA received them today, just before this oral hearing, and has not yet had time to review them. As discussed with the attorneys from FTB, there are no objections at this time. However, because FTB has not had time to review the exhibits, they will be given 30 days from the date of this oral hearing to file any objections with OTA. Appellant will be given 30 days after that to respond to objections, and a decision will be made on the exhibits at that time. Mr. Miller, Ms. Kyra, is that your understanding of the situation?
Yes, Judge Long.
Thank you. And will 30 days be enough time?
Yes.
Okay. And Mr. Tucker, Mr. Canestrelli, you understand that you'll be given an opportunity to respond to any objections?
Understood.
Okay. Now, with respect to the exhibits, because both parties have used alphabetical labeling, please refer to FTB exhibits by saying FTB exhibit, and please refer to appellant exhibits by saying appellant exhibit. Moving forward, At the pre-hearing conference, it was agreed that the following is not in dispute. First, the note and warrant purchase agreements 2 and 3 are not supported by copies of promissory notes, with the caveat that they may have been supported at one time, but there are currently no copies available for appellant to provide. 2, Solutions and Software Company did not pay any interest on alleged loans. And 3, because appellant is unable to provide written promissory notes for agreements 2 and 3, he is unable to establish a maturity date. Mr. Canestrelli and Mr. Tucker, is that your understanding of what was discussed at the pre-hearing conference?
That is not my understanding.
Okay. And Franchise Tax Board, is that your understanding as well?
Yes.
Thank you. Today's hearing is expected to take approximately 2 hours. We will begin with the appellant's opening presentation and witness testimony. You have 1 hour and you may begin when ready.
Good afternoon, Your Honor. May it please the court?
Oh, I'm sorry, real quickly, you don't, as I noted earlier, Office of Tax Appeals is not a tax court. It's an independent agency, so you don't have to use those formalities. And Judge Long, Mr. Long is fine. I appreciate the respect, but it's completely unnecessary to call me Your Honor, and you can just continue and go ahead without any further cues from me. Okay?
All right, perfect. As Judge Long previously stated, the only issue in this case is the FTB's denial of appellant Alan R. Brayton's claim for bad debt deduction of $3,525,000 for the year 2014. The appellant sought this deduction under IRC section 166 and conformed section of the California Revenue and Tax Code, section 24348. The key issues to determine are bona fide debt. The key issue to determine bona fide debt is Boatner v. Commissioner, which provide factors that are useful framework for distinguishing loans from equity, and each factor overwhelmingly supports appellant's position. In particular, there are 3 factors of the 13 which provide clear and convincing evidence. The first is the documents are labeled as promissory notes and note and warranty purchase agreements, terms typically in loan agreements. Second, the agreements specify fixed maturity dates, a key feature of loans. Third, appellant did not participate in the management of SIS, further reinforcing the intent to create a debtor-creditor relationship. The FTB argues that the funds transferred from Brayton Investments, which are going to be referred to as BI, to software or solutions in software, which are going to be referred to as SIS, were equity investments, not loan. However, this mischaracterization mischaracterizes the fact that the evidence, both documentary and testamentary, will show that these transfers were bona fide loans, and the appellant is entitled to the deduction. The core documentary evidence in a series of note and warranty purchase agreements executed between 2003 and 2005. This is evidence in appellant's exhibits H, I, and J, which are the first, second, and third note and warranty purchase agreements, clearly outlines the repayment terms, fixed interest, promissory notes. These are all hallmarks of bona fide debt as defined by the Treasury Regulation Statute 1.166-1. Moreover, there are documents that show the conduct of both parties after the agreement confirmed.
Mr. Tucker,
Yes.
I'm sorry to interrupt, but I do want to make sure that Ms. Rodriguez is able to catch everything that you're saying. If you could just slow it down a little bit. You're moving a little quick for me, and I'm not responsible for the transcript, so I want to make sure that we get everything that you're arguing. All right?
Of course. Thank you, Judge Long.
Thank you.
Moreover, There are documents that show the conduct of both parties after the agreement confirms a debtor-creditor relationship. Appellant never participated in the managing of SIS, and no shareholder rights were granted unless the warrants were exercised. An option never pursued by BI or Mr. Brayton. Exhibit D, which contains email exchanges between SIS's president, Mr. Spies, and appellant, further supports this. In one exchange, Mr. Spies acknowledges SIS's inability to repay and proposes converting the debt into equity as a last resort. If these transfers had been equity from the start, there would have been no need for this proposal. As we talk through this evidence, including appellant exhibits H, I, and J, we will show that Brayton Investments consistently acted as a creditor and not an equity investor. On the issue of worthlessness, by the end of 2014, SIS was in severe financial distress and unable to meet its repayment obligations. Appellant's Exhibit G, which contains emails from early 2015, includes a clear admission from Mr. Spies that SIS could not or could no longer repay the loan. This is corroborated by the profit and loss statements in Exhibit E, which show the company's deteriorating financial condition. Under IRC Section 166 and California Revenue and Taxation Code Section 24348, a debt is considered worthless when there is no reasonable expectation of repayment. Appellant made a prudent determination that the debt was worthless in 2014, as documented by the issuance of Form 1099-C. Testimony by appellant and Mr. Spies will confirm the documentary evidence. Finally, regarding the burden of proof. Under IRC Section 7491, once appellant presents credible evidence through promissory notes, financial records, and communication, the burden shifts to the FTB. The FTB will not provide sufficient evidence to rebut this. Their focus is on the existence of warrants which were never exercised. This does not change the nature of those transactions as loan. In conclusion, the evidence will clearly show that these transfers were bona fide loans that became worthless in 2014, entitling the appellant to $3,525,000 of bad debt deduction. We respectfully ask the panel to reverse the FTB's decision and deny and allow the appellant to claim the bad debt deduction.
And that is our opening statement. And now we are going to take direct testimony to the appellant.
All right. Mr. Brayton.
Yes.
Would you mind describing your professional background and current occupation?
I'm a personal injury attorney and have been for the last 40 years, primarily representing victims of toxic exposures, including beryllium, silica, asbestos, bad groundwater, and a variety of other things.
Okay.
And I'm the founding partner in the firm.
Okay. A successful firm, correct? Well,
I like to think we're successful.
Okay. In your practice, how often do you have access to companies' financial solvencies?
Well, I have access to my company's financial solvency on a regular basis.
Okay. When you are you familiar with bringing suits against corporations?
Well, I sue corporations in the course of the business. Many of the defendants in the litigation are corporate defendants.
Okay. How do you determine if a suit would give you money, right?
Well, I evaluate the strength of the underlying case, whether or not we can show negligence or strict products liability. And I look at the culpability of the defendants that we sue, and we rarely get into looking at whether or not they're judgment proof until we actually get a judgment.
Mm-hmm. If there's a company that you were bringing suit against without insurance, would that factor in afterwards? Would that factor in before or afterwards?
If I knew at the outset that there was no insurance, I might try and ascertain if the company was otherwise viable before proceeding against them.
Okay. Did you have any connection with Mr. Spies prior to investing in his company?
Yes, he was a vendor and was providing the case management software utilized by my firm.
Okay. When you signed an agreement with Mr. Spies, how was it structured?
Well, the agreements that I guess you're referring to are the promissory notes, where I agreed to lend him money through Brayton Investment Corporation, and they were structured as promissory notes, 7-year promissory note, and due, I believe, in 2010. And as part of that promissory note, SIS issued warrants that would allow me to exercise the right to play stock in the company.
Okay. Why did you invest in, or why did you provide a loan to SIS?
I provided a loan to SIS because I thought they had a good product. I thought that it was viable for my firm and would be viable for other firms, particularly those involved in mass tort litigation and other complex litigation. And I thought that the further development of that product would benefit not only my firm, but would have economic viability.
Did you ever convert your loan into equity?
No.
Why is that?
I never became convinced that that would be a prudent thing to do.
Did you have access, or when you reached out for repayment, did they provide you access to or information regarding their financial status?
Well, yes, at the outset, they provided me financial information and projections on where they thought the company was going to go and how they were going to expand it and provide a source of repayment. And then along the way, over the years, they would periodically provide updated financial information.
Okay. Did you ever attend any shareholder meetings, or were you involved in the management of SIS?
I never attended a shareholder meeting, and I never had any involvement in the management of SIS.
Did you record interest payments or other financial charges related to the loans and accounting records?
There were never any interest payments made, so no interest payments were ever recorded. In 2010, when they were due, they indicated they didn't have the ability to repay. And looking at their financial statements, I concluded that that was correct, that they couldn't. But they said, you know, we're still trying to expand. And so we continued to carry on until 2014.
Okay. When did you have access to these financial statements?
I believe that we got updated financial statements every year, kind of as a one-page summary of profit and loss. That was all handled through my chief financial officer.
That was Matt Fleming, correct? Okay.
Matt Flumer, yes.
Flumer. Okay. Perfect. Would you mind explaining your CFO's background for me?
Yeah, Matt was a graduate of West Point, served in the Army for 20 years and retired during that time. He became a certified public accountant, came out of the Army, came to me with a few years of experience in the real world, and we hired him as a CPA and chief financial officer for the firm.
Okay. Prior to prior to deducting this debt as bad debt, did your CFO and you talk about it, and did you consult outside CPAs to determine if it was reasonable?
Yes, we not only discussed it, we also consulted Terry Cumbie, an outside CPA.
Okay.
I'm sorry, can I have a spelling on, what was it?
Flumer is F-L-E-U-M-E-R. Cumbie is C-U-M-B-E-Y.
You said C-U-M-B-E-Y?
Yes.
Thank you.
Okay. Before declaring the debt worthless in 2014, what efforts were made? What did you do to ensure that you would what did you do to try to receive payment from SIS?
Well, we asked them repeatedly when they would be able to resume payments, and they let their financial statements speak for themselves.
Mm-hmm. Why didn't you bring suit against SIS?
I was pretty familiar with the company at that point, having watched their financials, particularly from 2010 to 2014. They had no assets, and bringing suit, I concluded, would be an exercise in futility. I would get a judgment that I didn't think would be collectible, and the best that would happen is I'd become a creditor in bankruptcy with very little likelihood of getting anything. So it was kind of like no point at that point and throwing good money after bad.
Mm-hmm. Were there any discussions about repayment plans or restructuring the debt prior to 2014?
At several opportunities, Richard offered to convert the debt to equity, and I didn't think that that would be in my best interest. And in fact, as late as early 2015, he still was offering to convert the debt into equity, but it made no sense.
In your communications with SIS, they provided you with financial statements over the course of years. And in 2014, what made this different than a minimal gain in 2013?
I think that in 2014, it had been another 4 years after the notes were due, and it appeared that it was not going to get any better unless they turned their business around. I was unwilling to advance additional funds, and they had no opportunity to go out and get additional funds with this debt overhanging his company. So if there was any prospect that he would be able to do something, it would only be if he didn't have the burden of this debt. And so I decided to write the debt off at that time.
Mm-hmm. Did you ever have any reason to believe that the funds advanced to SIS were anything other than loans based on your agreements and based on your conversations?
No, all they provided were warrants, and which were never executed.
Did SIS ever attempt to argue that the funds were equity contributions rather than loans?
No, in fact, up until the end, they made offers to convert the loans to equity.
In our exhibits, the first promissory note is not signed. Did this reflect your agreement? Was this ever signed?
I don't know if it was ever signed or not, and if it was signed, I don't know where it ended up.
Okay.
But
And
it accurately reflects our agreement.
And it was 20 years ago, and it looks like the wire transfers confirmed that you were acting as if the agreement was valid.
Yes, I always treated it as valid.
Okay. Did Brayton Investments ever issue a 9C?
I'm not a 1099-C or a 9C?
Yes, a 1099-C, sorry.
Okay. Yes, in 2014, we issued a 1099-C.
The second and third agreement do not have a promissory note attached to them. Was there a promise to repay?
There was a promise to repay. I don't know if they were ever executed as promissory notes or not. I just don't recall. And Mr. Flumer's no longer with me, so I could not locate notes for those agreements.
Do you believe that the course of conduct between you and Mr. Spies would indicate that there was an enforceable promise to repay?
I never had any indication from him that he didn't desire to repay it. He repeatedly said that he was looking forward to the business taking off. In fact, I think around 2009 or 2010, he laid out extensive business plans to show how he was going to grow the business and pay off the promissory notes.
Okay. No further questions.
Judge Long, do we do cross-examination now, or should we call the next witness for testimony?
I actually, thank you for asking. I was just about to offer Franchise Tax Board the opportunity to do the cross-examination now.
Okay.
Franchise Tax Board, do you have any questions for Mr. Brayton?
Yes, we do. Good afternoon, Mr. Brayton. Thank you for being here today.
Good
I
afternoon.
visited your website and I read your biography, and I'd like to ask you some questions about your background.
Sure.
So you received a Bachelor's of Science in Economics from the United States Air Force Academy in 1971. Is this correct?
That's correct.
You received a Master's of Science in Finance from UCLA in 1972, correct?
That's correct.
You received your law degree from UC Berkeley Bolt Hall School of Law in 1976, correct?
That's correct.
You were admitted to the State Bar of California in 1977, correct?
That's correct.
And you're the founding and senior partner at your law firm, Brayton Purcell LLP, correct?
Correct.
You founded your firm in 1984. Is this correct?
That's correct.
So you have approximately 40 years of experience owning and managing your own law firm, correct?
That's correct.
Thank you. So I'm going to reference your opening brief for the next few questions. In your opening brief on page 4, you state that, quote, the execution of a promissory note and warrant purchase agreement is a regular practice in corporate financing, end quote, correct?
Correct.
The promissory note provided with the first purchase agreement was not executed by SIS, correct?
That it was not executed?
Yes.
I don't know. I thought that they had executed the agreement. That's why I continued to provide the funding. But
Okay.
I don't have a signed copy of the agreement.
Okay. Next question. In your opening brief on page 5, you state that, quote, in the second and third purchase agreements, however, no promissory notes were executed, end quote. Is that correct?
I don't know if they were executed or not. That was a long, long time ago.
And for reference, the quotes are statements from your opening brief prepared by your attorney, which is in the record. Next question. In explaining the absence of executed promissory notes, on page 5 of your opening brief, you state that you were, quote, assured that if SIS does not issue promissory notes or warrants, a constructive or resulting trust would exist with respect to the funds transferred. Under Civil Code Section 2224, one who gains a thing by fraud, accident, mistake, undue influence, the violation of a trust, or other wrongful act is an involuntary trustee of the thing gained for the benefit of the person who would otherwise have had it, end quote. Have you filed an action against SIS to impose a constructive trust on the funds that you allege you transferred?
No, I have not.
In your opening brief on page 3, you state that, quote, when Brayton attempted to collect on its loan from SIS in the first quarter of 2015, SIS could not pay and instead offered to partially settle the debt via equity, as is evidenced by the email correspondences between the two companies' officers, end quote. So according to the statement, you were still attempting to collect on the debt in the first quarter of 2015. Is that correct?
No, I was not attempting to collect. That was a proposal that Mr. Spies made back to us as we were talking about doing the 1099 and documenting the fact that we were going to take it as a bad debt.
Okay, next question. Brayton Investment refused SIS's offer to take an equity position in SIS. Is this correct?
Yes.
SIS did not make repayments of principal to Brayton Investment. Is this correct?
That is correct.
In your response brief dated October 1st, 2021, on page 15, you state that, quote, Although the debt has been declared worthless in 2014, in case it is recovered in the future if SIS becomes financially viable, Brayton Investments can make such declaration of income in order to reverse the effects of its bad debt cancellation. End quote. Your statement indicates a possibility of collection of the debt in the future if SIS becomes financially viable. Is this correct?
I think it merely reflects that if Richard became wildly successful and decided to, notwithstanding the fact that we had written off the debt, to repay it, I would have to take it into income at that time.
Thank you. Those are all my questions.
Thank you. Mr. Tucker, Mr. Canestrelli, would you like to proceed with your second witness?
Do we do follow-up now, or do we do the second witness, Judge Long?
If you have questions for Mr. Brayton, go ahead and do those questions.
I have one question. As far as the FTB attorney's question regarding that you would take income if you were somehow repaid the debt in the future, what was your understanding of that as far as why you were required to take it up as income?
I guess my understanding was that if I was wrong and that it was not a bad debt and somehow it was paid to me in the future, that it would be appropriate to treat it as income. Now,
are you familiar with the tax benefit rule doctrine in tax law?
No, I am not a tax law expert.
Okay. All right. No further questions.
Thank you. You may begin with your next witness when ready.
Hey, Mr. Spies, thank you again for attending the conference and giving testimony. Can you please introduce yourself and explain a little bit about your role at SIS during these years, 2003 to roughly 2014? You're muted, Mr. Spies. We still cannot hear you.
Mr. Spies, we seem to be having some microphone troubles again, so we're going to take a quick 5-minute break and someone from OTA will reach out and help you, okay? And in the meantime, everyone else will be returned to the waiting room and the ALJs on the panel will also. All right, is everyone ready to go? Okay. Ms. Rodriguez, are you ready? All right, we're going back on the record. Mr. Canestrelli, you may begin when you're ready.
Okay. Hello, Mr. Spies. How are you doing today?
I'm doing pretty well.
Okay. Can you please introduce yourself and explain your role at SIS during 2003 through 2015?
I've been president CEO of the company since actually when I joined the company.
And what is the company?
Beg your pardon?
No, go ahead. I apologize.
I joined the company as a partner initially in 2000 and developed and oversaw the development of the product. And Mr. Brayton was one of the early clients in the process and been managing that ever since. Not a technology person, so I do have a finance background.
And can you explain a little bit more about your finance background?
It was securities as well as commercial real estate, Reg D offerings back in the 80s and 90s. Worked for J.E. Robert, X Venture for a while, which had a lot to do with securitizing assets. Started my own development company. So did real estate, which of course involves finance. And then in 2000, I joined SIS, and within a short period of time bought out the president of the company because we had different ideas on what we should do, and been operating the company since then.
Thank you. You had mentioned that Mr. Brayton was a client of SIS. When did you start discussing his loan to SIS?
Well, Mr. Brayton had already engaged with the company, but by the time I company, so they were already in the process of negotiating a software agreement or demonstrating the software back in 2000, 2001. We deployed at that point. I met Mr. Brayton during that time, and I suppose it was sometime in 2002 that I thought it would be a idea to get financing for the company so that we could expand our platform more quickly.
Mr. Spies? Mr. Spies, I'm sorry to interrupt you. There's some audio quality issues, and they seem to increase when you scoot away from your microphone. So maybe try just staying a little closer to your microphone, and hopefully that helps. Thank you.
Okay. So did you catch most?
No, I did
I
not.
didn't get that last part. It's kind of choppy when he does speak, so it's getting kind of hard to get everything down. His connection is a bit choppy.
Okay, seem to be having plenty of audio issues today.
Yeah.
I'll try to speak more slowly and be clear.
Okay.
So I met Mr. Brayton after the company had engaged with him, after he had purchased the software. Told him that I would like to grow the company more quickly, of borrowing funds from him because he obviously had a very successful operation, and he was a client. So I thought the prospect would be good, and he agreed.
And what was your understanding of the investment, as a loan or as equity?
It was a convertible note as far as I was concerned. I've always referred to it as a note of debt.
So
I'm sorry, repeat that last part. You said I always refer to it as a note, and then you cut off.
I refer to it as a note, and you see that in my correspondence. and I've always viewed it as a debt obligation.
Did you ever treat Brayton Investments as a shareholder of SIS, send them notice of shareholder meetings, ask them to vote for directors, anything of that nature?
Not at all.
Okay. I have provided appellates exhibits H, I, and J, which are the series of note and warrant purchase agreements. Did you get a chance to review those?
I looked at them quickly.
Do they seem like the documents that were prepared to memorialize the loan at the time?
Yes. When we originally entered into the first document, I had pretty comfortable with the way the note and
I'm sorry, Mr. Spies.
written.
I'm sorry. Can you repeat the last few sentences? I wasn't able to hear what you're saying. And actually, since you're having significant microphone issues,
Would you?
it may be best for you to turn off your video to increase the bandwidth, or to use the phone audio option of this meeting. So I would suggest that we start with maybe turning off your video, so that that might increase your bandwidth.
Okay.
Okay, let's give that a try, and I hope we I hope it works better. And if you could just repeat the last few things that you had said, so that we can all understand.
I was asking you a question about exhibits H, I, and J, the note and warrant purchase agreements signed between SIS and Brayton Investments. Did those seem like the documents that were signed back in 2004?
They reflect my understanding of our agreement. Yes.
Do you know if there are any signed copies of both sides of those notes?
No, when
And
the
more-
question initially came up, I did look extensively for the documents, and I've been allocate them.
Was your understanding that those agreements were enforceable?
Yes.
So if you look at appellate's exhibit C, which has the breakdown of the financial transactions between Brayton Investments and SIS, does that look correct, as you recall?
Correct. I went back and looked at a balance sheet for 2013, and the amounts coincided.
Okay.
So we reflected that as a debt.
And if you look at appellate's exhibit B, which are wire transfers from Brayton Investments to SIS, do those reflect what you recall the monies coming into SIS?
Yeah, obviously it's difficult to remember all of the transactions that occurred, but yes, that seems to reflect, it seems likely to reflect what occurred. And I did provide bank statements as well, so I assume those would match up.
So take me through what happened as far as repayment is concerned. Did SIS ever repay any either interest or principal on these notes?
No, we were unable to. We cut back on staff. We at one point we had 19 or 20 employees. When ceased from Mr. Brayton, we got no further loan proceeds, and we had to cut back our staff substantially. I'm sorry, did I lose track of the question there?
No. So when did you inform Mr. Brayton that you would not be able to repay the loan?
I believe it was, yeah, that's a definitive statement. I'm not able to repay the loan.
Oh,
My probably have been, for instance, when I'm making proposals to him, would have been something to the effect of, in an effort to get him some kind of recovery, to tell him that we could get no additional funding carrying a debt burden of millions of dollars. I had no additional sources of funds. So I didn't say I can't repay your loan, but I certainly gave him the impression that I wouldn't be able to repay the loan unless we did something to restructure the debt. And part of at least one or two proposals in restructuring the debt was to convert to equity, an equity position, and write a substantial part of the debt.
and did Mr. Brayton accept an equity position versus a debt position?
No, he did not.
So going to 2014, forward to 2014, what was the financial situation of SIS at that point?
Desperate. I was investing some of my own funds at that point, taking a salary over that 5-year period leading up to that point. My salary probably averaged under $40,000 a year. There were no distribution of funds at all to the shareholders.
And
obviously there was no possibility of repaying the debt.
So at that point in 2014, did Mr. Brayton start discussing just discharging the debt at that point?
Yes, I believe it was primarily through Matt Flumer
And
that conversation occurred.
And were you aware of what the tax implications to SIS would be if they discharged the debt?
I contacted an accountant to make certain that my understanding was correct. But yes, my expectation, if they forgave the debt, it would become income to me or my company. And in becoming income to SIS, the question was, should we have losses to offset it? And because we had essentially spent all the money on expenses of operation, it was pretty clear that we would come pretty close to being able to cover the 1099 income with the carry forward losses.
Was that information shared with Mr. Brayton?
Yes.
And was a 1099-C issued from Brayton Investments to SIS for 2014?
Yes.
Was there any formal paperwork between the two companies that indicated that this debt was now discharged and they were no longer going to pursue it?
Yes, I was notified by email that the debt had been discharged and that a 1099 would be issued.
All right, I have no further questions for this witness.
Thank you. Franchise Tax Board, do you have any questions for Mr. Spies?
Good afternoon, Mr. Speed. Thank you for being here today. I have one question for you. Is SIS operational today?
Yes, it is.
Okay, thank you. Those are all my questions.
Thank you. Before we move forward with Franchise Tax Board's presentation, or actually, sorry, before we move forward, Mr. Canestrelli, Mr. Tucker, does that conclude your opening presentation?
Yes, that does, Your Honor.
Okay. Before we move forward with Franchise Tax Board's presentation, I'd like to turn to my co-panelists. Judge Ralston, do you have any questions?
No questions at this time. Thank you.
Judge Long, do you have any questions?
I'm going to hold my questions till the end. Thank you.
Thank you. I just have a few questions. With respect to the 2014 return for Brayton Investments, it does show a deduction for other investments as opposed to a deduction for bad debt. Is there an explanation for the CPA's characterization of this deduction, of the deduction in this way on the return?
I don't know what that explanation might be. I just rely on the CPAs.
Fair enough. Was it the same CPA that recommended that you write off this as a bad debt deduction?
Yes, it was not Mr. Flumer. I think the returns were prepared by CCK, Mr. Cumby's firm.
Okay. And then with respect to appellant's opening brief, I think we've already covered that no promissory notes were issued with respect to the second and third agreement, and Mr. Brayton or your representative from Brayton Investments protested the non-issuance. Were those protests in writing? Is there any documentation available of that type of protest?
I don't recall.
Okay.
I mean, we didn't find anything when we looked.
Okay. Thank you. And then Mr. Spies, just very quickly, my understanding from the file is that in 2014, you informed BI that you'd be closing your business. Is that correct? Mr. Spies, are you there?
Yes, I believe it was something to the effect of I cannot continue to operate with the debt load we're currently carrying. So we would have to close the business.
Okay. Thank you. And I believe that concludes all of my questions for the moment. Franchise Tax Board, you requested, hold on one moment.
I actually have one moment to start a new file. Just
Yes.
Okay, thank you.
Sure. So we're off the record for a moment, but don't go anywhere.
Okay, thank you. I'm ready.
Thank you, Ms. Rodriguez. Let's go back on the record. Franchise Tax Board, you requested 30 minutes to make your presentation, and you may begin when ready.
Thank you. I think we'll take less than that. Okay. The issue before us today is whether appellant has established that he is entitled to claim a pass-through loss of approximately $3.526 million from his wholly owned S corporation due to the S corporation's claimed bad debt deduction in the tax year 2014. I will outline the pertinent facts of this case. Appellant is a California attorney and a supervising partner in Brayton Purcell LP, a California law firm. Appellant is the sole shareholder of Brayton Investment Company, an S corporation, which I will refer to as Brayton Investment. Brayton Investment purportedly made wire transfers totaling approximately $3.525 million to Solutions and Software, a Texas corporation, which I will refer to as SIF. These transfers were made between March 2003 and December 2005. Brayton Investment reported these alleged transfers as other investments on its income tax return. Appellant provided copies of 3 note and warrant purchase agreements, which I will refer to as Agreement 1, Agreement 2, and Agreement 3, and provided corresponding documents that he contends substantiates the transfers of funds between Brayton Investment and SIS. Additionally, appellant provided a series of emails between Brayton Investment representatives and SIS representatives, which appellant contends substantiate SIS's insolvency and inability to repay the transferred funds. In a letter provided at audit, appellant stated that in December 2014, he was notified by the president of SIS that SIS would be closing and all staff was to be released. This would affect Brayton Investment's investment in the company. Appellant further stated that based on advice from the CPA and tax attorneys, it was determined that appellant's investment in SIS should be written off as there was no hope of redeeming the SIS notes for loan. Now, I will explain how these transfers were reported on the tax return. Brayton Investment reported these alleged transfers as other investments on its income tax return. On its 2004 return, Brayton Investments reported investments in SIS totaling $1,550. On its 2005 return, Brayton Investment reported investments in SIS totaling $3.525 million. Then, on its 2014 tax return, Brayton Investment reported an ordinary loss of $3.526 million approximately relating to investments in SIS and 0 bad debts for the tax year. Brayton Investment issued appellant a 2014 California Schedule K-1 and reported appellant's pro rata share of its ordinary business losses as approximately $3.526 million. Appellant then reported his pass-through business loss on his 2014 personal tax return. Appellant contends that the purported transfers reported as investments in SIS were actually loans which became worthless in 2014, and therefore Brayton Investment was entitled to a bad debt deduction. Now I will go over respondent's position. Respondent's position is that 1, appellant has failed to establish the existence of a bona fide debt, and 2, failed to establish that the purported transfers of funds reported as an investment became worthless in 2014. I will speak to the relevant legal authorities. Internal Revenue Code 166 subsection A allows for the deduction of a business debt that becomes worthless within the taxable year. Under Treasury Regulation Section 1.166-1 sub C, only a bona fide debt qualifies for purposes of a bad debt deduction. A bona fide debt is defined as A debt which arises from a debtor-creditor relationship based upon a valid and enforceable obligation to pay a fixed or determinable sum of money. If the existence of a genuine debt cannot be established, the advance of funds, if any, may be considered a gift or a capital contribution, either of which is not a debt. Whether a bona fide debtor-creditor relationship exists is a question of fact to be resolved in light of all pertinent facts. An essential element is whether there is a good faith intent of the receipt of the fund to repay and a good faith intent on the part of the person advancing the funds to enforce repayment. The taxpayer bears the burden of proving a bona fide debt existed. Appellate contends that agreements 1, 2, and 3 evidence a debtor-creditor relationship between Brayton Investment and SIS. Appellant relies on the factors in Boatner v. Commissioner to establish the existence of a bona fide debt. This is the incorrect case. Boatner v. Commissioner analyzes loans versus investments to a closely held corporation. In Boatner, the purported loan is between petitioner and his closely held corporation. Facts are inapplicable to the facts of this case. The correct case is Welch v. Commissioner. In Welch, the court defined a loan as an agreement, express or implied, where one person advances money to the other and the other agrees to repay it on terms such as time or interest rate, as the parties may agree. The court stated that in making this determination, courts consider several factors as indication of a bona fide loan. I will go over each of the 7 factors. I will analyze how appellant has not met each of the factors, how appellant is not credible, and how appellant's contentions are based on a series of contradictions. The first factor, whether the promise to repay is evidenced by a note or other instrument. The only note that appellant provides to substantiate the existence of a bona fide debt is a note in Exhibit B from Agreement 1, which is not signed by SIS. So the note alone is not evidence of its validity. An appellant has not established that the note was valid or enforceable by Brayton Investment. Also, appellant concedes that Agreements 2 and 3 are not supported by promissory notes or security interest. Appellant has not provided a single fully executed promissory note or other instrument that supports a promise to pay a bona fide debt. Additionally, Brayton Investment's own bookkeeping records and tax returns, all prepared by the same CPA and signed under penalty of perjury by appellant, all account for the alleged transfers as investments and not loans, and account for 0 in bad debt. However, in an email between Brayton Investment and SIS dated January 28, 2015, the same CPA discusses uncollectible loans and the issuance of a Form 1099. Appellant provided no explanation for these contradictory statements. Appellant has failed to establish that the promise to pay is evidenced by a note or other instrument. The second factor, whether interest was charged. Appellant admits that SIS failed to pay interest. Additionally, appellant has provided no evidence to substantiate that Brayton Investment ever actually charged any interest or even attempted to enforce interest payments, much less if any interest was paid. Number 3, whether a fixed schedule for repayments was established. Firstly, appellant concedes that repayments were not made. Second, there was no repayment schedule established by agreement, by note, or by any other instrument. The promissory note attached to Agreement 1 specifies a principal amount with a 5% interest rate with a fixed maturity date of November blank 2010. However, the date is incomplete, and the note does not include a fixed schedule for repayment. As previously noted, appellant concedes that neither Agreement 2 nor Agreement 3 are supported by promissory notes or security interest. An appellant provided no evidence that either of these agreements provided an interest rate, a fixed maturity date, or a fixed schedule for repayment. Number 4, whether collateral was given to secure payment. Appellant has not contended that Brayton Investment received any collateral to secure payment, and there is no provision for collateral in the only promissory note in Agreement 1. In a January 8, 2015 email, SIS offered Brayton Investment an equity position in SIS in lieu of debt. However, in a subsequent email dated January 23, 2015, Brayton Investment rejected SIS's offer of collateral and opted to write off the alleged debt. Number 5, whether repayments were made. Appellant conceded that no repayments of principal or interest were ever made. Number 6, whether the borrower had a reasonable prospect of repaying the loans and whether the lender had sufficient funds to advance the loan. Appellant conceded that SIS periodically provided financial statements to Brayton Investment that showed SIS's inability to make any interest payments on the $1.45 million note in Agreement 1 due to issues with cash flow. Additionally, appellant conceded that Brayton Investment did not enforce payments of interest or principal of the note in Agreement 1 at its maturity date, because in reviewing SIS's financial statements, it became clear that SIS had no ability to satisfy their loan obligations. Number 7, whether the parties conducted themselves as if the transaction were a loan. Brayton Investment did not appear to maintain corporate formalities with respect to the purported loans, and the alleged arrangement was largely undocumented. Appellant produced a single incomplete and unexecuted promissory note for $1.45 million, which does not contain a repayment schedule or collateral to secure a payment. The absence of these provisions suggests that it is not a bona fide debt. Appellant has an undergraduate degree in economics, a master's in finance, and received his California bar admission in 1977. Appellant is a sophisticated business person. His 2014 tax return shows appellant has a large and sophisticated portfolio of investments and businesses. Appellant has been a licensed and trained attorney for 40 years, a supervising partner of a law firm, and thus appellant's conduct and Brayton Investment's conduct does not add up. Brayton Investment reports the purported transfers as investments. However, appellant contends they are loans but cannot provide substantiation. Appellant opted to lend 3.525 of funds, Appellant opted to lend $3.525 million of funds without collateral or promissory notes and with incomplete agreements. It doesn't make sense that appellant would transact a business arrangement without corporate formalities. According to appellant's own arguments, after SIS failed to make any interest payments on the first purported loan, Brayton Investment continued to lend money, and then after SIS offered an equity position in SIS in lieu of debt, Brayton Investment declined any form of repayment and opted to forgive all $3.525 million without accounting for interest. Brayton Investment never filed suit against SIS or attempted to secure repayment under Civil Code Section 2224. Appellant's contentions are contradictory and inconsistent with basic business and legal practices. Appellant has failed to establish that the alleged debt became worthless during the 2014 tax year. Assuming that the amounts transferred constituted a debt, the determination of whether appellant is entitled to a bad debt loss deduction turns on whether the alleged debt SIS owed to Brayton Investment became worthless in 2014. Most courts consider both the liquidating value and the potential value of the company to determine the year of worthlessness. In Bilthouse versus United States, the court reasoned that even where a company has no liquidating value, evidence of a potential value can be used to demonstrate that a company is not yet worthless during a particular year. In that regard, SIS was still in business during the year at issue based on appellant's own assertion and remains in business to this day. This refutes the assertion that the alleged debt became worthless in 2014. Additionally, in his reply brief, appellant indicated that he still had hoped to recover the alleged debt because it still has potential value due to the possibility that it will be collectible in the future. By appellant's own admission, the alleged debt is not lacking in potential value. In any case, appellant has not substantiated that SIS was in financial trouble. Appellant has not provided credible evidence to show the existence of a debt and its worthlessness in the 2014 tax year. This concludes respondents' argument. Thank you.
Thank you. I would like to turn it over to my co-panelists to see if they have any questions. Judge Ralston, do you have any questions?
No questions. Thank you.
And Judge Long, do you have any questions?
I do have a question for FTB's counsel. During appellant's counsel presentation, they discussed a burden shifting that supposedly would take place in the event that appellants are able to meet their burden of proof. And when I confirmed in the briefing, they're citing to Internal Revenue Code section 7491. I just want to ask FTB, does Internal Revenue Code section 7491, does that apply in this case? Does California conform?
It does not apply in this case, Your Honor. The burden of proof standard under 7491 refers to a court proceeding where a taxpayer introduces credible evidence with respect to any factual issue relevant to ascertaining the liability of the taxpayer. Even if it did apply, appellants haven't produced any credible evidence with respect to any factual issue as outlined in our presentation. The burden rules are very specifically identified in the OTA's own regulations.
All right. Thank you, FTB. I just wanted to go ahead and confirm because I didn't see it discussed in the briefing specifically. Thank you.
Certainly.
That's all of my questions for FTB at this time.
Thank you, and I think that clarifies my questions as well. So, with that in mind, we are going to move on to appellant's final statement. Mr. Canestrelli, Mr. Tucker, you requested an additional 10 minutes to make your closing argument, and you may begin when ready.
Okay. FTB's position that this was a secret equity purchase, contrary to all the documentation and the testimony, is nonsensical. If it was an equity purchase, Brayton Investment could have deducted their investment as an S corporation shareholder annually, wouldn't have to wait until 2014 when the debt was completely unpayable to try to recoup their investment with a cancellation of debt for tax purposes. So I do think that appellate has shown documentation and testimony evidence that shows that the appellant is entitled to the deduction. I do think that Bontner versus Commission is the correct case for this situation because it directly addresses the core issues that we are facing. The distinction was bona fide debt and equity. Welsh versus Commissioner is more focused on ordinary versus necessary business expenses, which is not an issue in this case. I do think that the note and warrant purchase agreements and the testimony and the history of this debt for 10 years shows that we have, under the Bontner test, have proved that there was legitimate debt. The name given to the instrument, promissory note, and warrant purchase agreements, that's one of the Bontner factors, and I think that's in favor of it. Fixed maturity debt, not on all of the notes, not on all the agreements, but there was on at least one. Again, something that shows a debtor creditor. Source of repayment, SIS was supposed to make a lot of money on their software. It didn't happen, but that was what the petitioner was relying on the payment. Right to enforce payment, again, those documentations and everybody's understanding was that Brayton Investment could enforce their right. There was no participation of management by Brayton Investment at any stage. adequate capitalization. SIS faced financial difficulties. Brayton loans were there to help them capitalize it. And they were hoping that this software would take off and everyone would be paid and Brayton would be paid back. Intent of the parties, I don't see anything that points to any type of an equity intent. That would have been, like I said, more favorable to appellant if they would have treated this as equity from the get-go. And then the other factors, taken all in all as put in our briefs, I think we have met the standard of the 13-point factor test of Boatner. As far as the worthlessness of the debt is concerned, the evidence strongly concludes that it became worthless in 2014. SIS could not do what they were doing. They couldn't function. Yes, SIS still exists, but it probably exists because of the discharge of the debt. As far as the appellate's statements regarding that maybe he'll get paid back again, he's just following the tax benefit rule, which indicates that if something changes down the road and you received a tax benefit, such as a cancellation of debt, and then somehow some miracle now 10 years beyond that you somehow get paid this debt, you are supposed to pick that up in the income as income in the year received. I don't think that is ever going to happen. It's been discharged. And I don't think the client is ever going to get paid. But if he does, the tax benefit rule would compel him to pick that up as income in the year received because he took the tax benefit rule. In conclusion, I think the facts, the documentary facts, yes, they are not complete, but this is a transaction from 20 years ago. But it certainly is strongly evidence that this was a debtor-creditor relationship, not an equity relationship, and that the debt became uncollectible in 2014. And we respectfully request that this court reverses the Franchise Tax Board denial of this deduction. Thank you.
Thank you. And before we conclude this hearing, I just want to double check with my co-panelists. Judge Ralston, do you have any questions before we go?
No, thank you.
Judge Long, do you have any questions before we go?
I do have one question for Appellant's counsel. Mr. Canestrelli, you said that if this had been reported as equity instead of debt, that there would have been losses being taken among the years before without waiting for 2014 to have a bad debt deduction. I just want to confirm my understanding. That was in your closing statement, is that right?
That is correct.
All right. So are you making an alternative argument that if this were to be considered equity instead of debt, that appellant should be allowed some amount of loss?
No, I am not. I'm just pointing out the Franchise Tax Board's position does not reflect on the reality of the situation. Why wait 10 years and not getting paid if this was equity all along? And that's my understanding of Franchise Tax Board's position. This is somehow crypto equity that he invested in. Don't look at the warrants. Don't look at the testimony, the understanding, the emails back and forth. This was equity all along, which makes no sense, because if it was equity, wouldn't he take advantage of it for 10 years?
All right. Thank you, Mr. Canestrelli.
Thank you.
Answer my questions.
Judge.
Thank you. with that, we are ready to conclude this hearing. As discussed at the beginning of the hearing, the record will be held open for 30 days, which in this case is October 17th, for Franchise Tax Board to review the documentation which was received today and provide any objections. At that time, if there are any objections, appellant's counsel will be given the opportunity to respond. Thank you to everyone for appearing today. The administrative law judges will meet and decide your case later on, and will send you a written opinion of our decision within 100 days of closing the record. Today's hearing in the appeal of Brayton is now adjourned, and this concludes our calendar for the day. Thank you.
Thank you, judges.
Thank you, judges.
Thank you.
Thank you.